inform the more serious players like you and Himanshu that, well, there is an office, we should go there.
Sir, Himanshu, good afternoon, Dr. Bishnoi, Payaswini here.
हाँ, गुड आफ्टरनून पायस्विनी। वो मैं फिर जब पीएचडी कर लूंगा तब आप डॉक्टर बोल लीजिएगा। वैसे अब सोच रहा हूँ एनरोल करने की।
So I have another of your colleague on as a silent sort of panelist on this. So yeah, between that and you, I think the prefix got mixed up. So my apologies.
Okay, not at all, not at all.
So I was just saying,
we're live. We're live now. Sorry. We're live now. And so, Mr. Bishnoi, sir, can we please begin with your permission, sir?
Certainly.
Great. Okay. So, thank you all for joining in to this panel 2 of the annual CII conference on competition law, which CII is jointly hosting with the Competition Commission of India. My name is Chitra and I represent CII here on this call. I'm going to start with a very, very quick round of introduction of our panel members. And with absolute great honor, we welcome Mr. Bhagwant Singh Bishnoi, Honorable Member, Competition Commission of India. Moderator, Ms. Payaswini Upadhyay, who you all know is from Bloomberg Quint. And our panelists this afternoon, Mr. Himanshu Dudeja from Blackstone India, Mr. Nilesh Limai from FMC, Dr. Sanjeev Ghimawat from Dalmia Bharat Group, and Mr. M.M. Sharma from Vesh Associates. And a very warm welcome to our distinguished guests from CCI and friends from the media. This panel, as we know, is going to be focusing on discussing merger control, which is one of the most integral parts, as we're all aware, of competition law regulation. The Ministry of Corporate Affairs earlier this year, invited public comments on the Competition Amendment Bill. The bill, has sort of proposed further recommendations. It's basically furthered the recommendations of the Competition Law Review Committee, which we're all, aware was constituted in October 2018. And, the report sort of came out in July 2019 with some very, very forward-looking recommendations. Now, as we're all aware, some of the proposed recommendations are indeed extremely important to discuss in details and may indeed have to now be reconsidered due to the onset of the pandemic and the resultant digital transformation. Some of these issues that I can think offhand could be differential thresholds, on-market transactions, what the definition of control is going to be, whether it's going to be material influence or is it going to be decisive influence, and so on and so forth. So the panel is going to be, focusing on some of these topics, and we will also be discussing the success of the Green Channel India, which has been sort of mentioned a couple of times since morning. I mean, we had the inaugural session and we had a great panel 1. So we've also requested panel members to discuss specific nuances of distressed sales, debt deals, FII deals, and of course, approval of resolution plans, which kind of now qualify as combinations under CIRP in the IBC. So without taking much of your time, a very quick word for our delegates. Our esteemed panel members have kindly agreed to take a few questions from participants. So you may like to ask your questions by way of chat, and we will request the moderator, Payaswini, to sort of kind of take it up. And with these words, I am very happy to hand this over to you, Payaswini, straight, for your remarks. And this will be followed by a very special address by Honorable Mr. Bishnoi. Thank you, Payaswini. All yours.
Thank you, Chitra, for leading us all into warming us all up, actually. Of course, it's been a tough year for businesses, policymakers, courts, and of course, regulators are no exception to it. As we entered the lockdown, amongst the biggest worries that corporate India had was how agile its regulators will be. And if I'm not mistaken, the Competition Commission of India was among the first few regulators to put out an advisory on how notifications will be filed and virtual hearings will take place. So I will begin by complimenting the TCI for its agility and promptness. On the specifics of the panel, I have 4 broad themes in mind today. I'm calling it 4 I's: inconsistency, interesting, irritants, and ideas. But before I go to the panelists with these themes, and I'm sure all of our audience is waiting for it, I'll request Mr. Bishnoi to open the session with his address.
Okay. Thank you very much, Payaswini, and thank you very much, Chitra. Good afternoon, friends. I'd like to begin on a personal note. I'm very happy to be participating in CII's annual conference on competition law and practice. This is the first time that I do so. However, I'm no stranger to CII, and I think it's also vice versa. We have worked closely together during my various assignments in the Indian Foreign Service, and I can attest without the slightest hesitation to their complete professionalism and to the utility that they bring both to government and to industry through all their endeavors. As these are the nature of introductory remarks, I will confine myself at this stage to highlighting the philosophical underpinnings of our approach to merger control. We are fortunate to have Ms. Payaswini Upadhyay as our moderator today. She is, as we all know, the most competent person for the job. I spoke to her the other day, and she advised me to focus on hearing the panelists. So that is what I propose to do, at least to begin with. We have a first-rate panel. Merger control is a niche area, and in this area, we have today the creme de la creme of those who deal with mergers and acquisitions on a regular basis. Dialogue with stakeholders is an important function for the regulator. On behalf of the Competition Commission, I thank the CII for bringing together today some of the most important stakeholders in the country with regard to merger control. While I have the utmost respect for academics, I do want to say that a meeting today will, I believe, go beyond being a mere academic exercise. Without further ado, I will now get to our philosophy on merger control. While fair competition for greater gain is a motto, the context is the economic development of the country. This is explicitly stated in so many words in the preamble of our Act itself. While we are the competition regulator for the country, we have no difficulty in acknowledging that competition cannot be an end in itself. It can only be a means to achieve a larger objective. The Commission recognizes that mergers and acquisitions are needed and are in fact useful to allow enterprises to attain the size, scale, and efficiency that is required for success in domestic and global markets. So while we promote and sustain competition in markets, we also have a duty as a regulator to, number one, provide certainty. Number two, reduce compliance requirements. Three, make filing simpler. And four, align our processes with international best practices. These are four principles, and the idea of today's session, in my view at least, is twofold. One, to add or subtract to these principles, and two, to brainstorm on what can be done to achieve our common objectives. Before I conclude, I must acknowledge the very challenging circumstances in which we are meeting today. If it had not been for the pandemic, we would be in Mumbai, the usual venue for this conference. My colleague in the Commission, Dr. Sangeeta Verma, has just concluded chairing a panel on the subject of competition compliance in the COVID era. I'm sure there would be useful suggestions on the way forward that would have come from that panel. However, if participants in this panel wish to also comment on the topic, I will be happy to take note. With these words, I now place myself in the hands of a most competent moderator for the rest of the proceedings. Thank you.
Thank you, Mr. Bishnoi, for your very kind words. Two very helpful sort of points that you made for me to segue, into the discussion. One is that you said that you believe this panel or this conversation would more be along the lines of what practitioners would look forward to, and not just an academic conversation or a philosophical one, because where's the fun in that? So I'm glad that we're going to talk on some of the headline sort of deals that came out of the CCI this year, and look at those nuances to figure out the precedents that the regulator has set for the rest of the industry. The first point that, of course, the broad umbrella that I'm going to touch upon is the inconsistency. And again, the first point that that Mr. Bishnoi made was that the regulator strives towards certainty, but some of the decisions that have come out of CCI suggest otherwise. And I would, of course, like the panelists to weigh in on the certain examples that I'm going to bring up. You can steer clear of the names, but as a journalist, without sort of citing examples, we have little to go by. The first sort of point that I'd like to make is in the context of Adani's acquisition of GVK. It was a green channel approval, and which was rather surprising for me, given that the company has won the bids to operate airports at 6 other locations. There was no assessment on substitutability or overlaps. Nilesh, I'll come to you with this first. Did you find it surprising that a transaction of this nature not only applied for the green channel, but also successfully made it through?
Yeah, thanks, Payaswini. So if you don't mind, I'll just quickly start with what this green channel route is.
Sure.
Basically, this gives an option to the parties to the combination where they can self-assess based on specified criteria and pre-filing consultation with CCI and check if they qualify for a green channel approval. And basis that, once they make the filing, unless there are any inconsistencies which CCI comes back to them, it is a deemed approval. So under this route, the parties basically don't have to wait for a statutory 210-day standstill period to expire to sort of effectuate the transaction. Now, specifically talking about this particular deal, I think the Commission noted in this matter that both the acquirer as well as the target directly or indirectly were engaged in the business of development, operation and maintenance of the airport or provision of access to airport facilities and premises. I think the Commission also further noted that the relevant product market could be demarcated in this case, and only the geographical market in the present case appears to be as narrow as each airport of the parties. As to providing services or for availing services, the service provider or consumer needs to have access to facilities and premises of the concerned airport. Therefore, the provision of services at one airport cannot be substitutable with another. Hence, the relevant market or the relevant geographic market in this case is each specific airport. And presence of parties in the same line of business, therefore, was concluded is not likely to raise any competition concerns. So I think the Commission also looked at the submissions that were made by the parties. And based on that, they noted that there does not exist any vertical relationship between the parties to the combination, and no existing vertical overlap as well. So that's what my view is. But I'll look to hear from the other analysts what's their view on this.
Okay, Mr. Sharma, let me come to you. How are you viewing this, not this as just a specific case, but in the sense of the signal this sends to the industry that whether you're looking at green channel, the CCI will strictly look at the narrowest definition of the micro market that it has defined, and probably the seemingly intuitive response to a filing like this that look, and CCI has held in the past that in the micro markets in this sector, you become a monopoly. So at the larger geography of India, intuitively, you would think that this would require a further investigation, which didn't happen in this case. So what would your takeaway be from this?
Thank you, Payaswini. In fact, this is a one-off case according to the CCI has gone and given a very narrow definition. There is another case which I remember of TRI urban transport, where the same airport defined as operation, development and maintenance of airports in India. And moreover, Schedule 3, which is attached to Look at all
Mr. Sharma, if I could interrupt here a bit, I think if you have another device on around you, if you could switch it off, that might be helpful because there is a little interference in your speech in that.
Am I better now?
Yeah, this is much better. I think it's still echoing. Do you have another device on around you that you'd like to sort of switch off?
Now is it better?
Yeah, so it will help if you're just logged in from one device. Otherwise, it will continue to interfere.
No, I am already logged into one device only. I have to log in again.
Okay, while Mr. Sharma joins us back, Himanshu, I'll come to you on, you may not want to specifically comment on this case, but like I asked Mr. Sharma, what is the takeaway for you when you look at the kind of assessment that the regulator has done in it? And is it inspiring that, the Adani made a conscious call to go via the green channel route, which everybody tells me was a surprising move, and more than that, the outcome of it.
Yeah. No, you're putting me on a spot, but I'll try and attempt on this one. Firstly, before I really get to the answer on this one, let me just say two things on behalf of the industry, because private equity industry keeps coming up in every conversation. I just do want to make two quick points. I think the effort by CCI this year has been world class. And when I say world class, I mean it. The kind of approvals we are getting, the kind of engagement we have is just phenomenal. So I just want to place that on record and express a very special thank you to the chairman, to Mr. Bishnoi and the rest of the team. We couldn't have asked for a better regulator at any time, especially during COVID, when we saw how the world was reacting. That's one. And two, this session is incredibly helpful because now we are really talking about things where we are exchanging real thoughts that really affect us on a day-to-day basis. So again, I don't think any regulator in the world, I say that with a lot of responsibility, which does this so periodically and in such a constructive way that all of us come together without having any face to this conversation, and we're talking about some very critical issues. So again, a very big thank you on that. Now, answering your question, I would say two things. I think insofar as Green Channel has been concerned, it's been a huge success. Now when the deals are happening, wherever there was a concern on the timelines, wherever there was a conversation that there are no overlaps, especially from a financial. That would be great. Thank you. So Green Channel, as we all understood, was for the purposes where somebody's getting into a market for the first time or has very less market share or less market, so to say, and therefore you didn't have to burden the commission and the parties to go through the same rigor as you would apply to Form 1 or Form 2, as the case may be. Now, if such rule has been applied to some of the strategic sort of players, again, I would not comment on the specific one, but if a strategic player has had some market share all across the country, it's a very subjective point in terms of how do you define market. Are you talking about somebody can be monopolistic? Are you defining Maharashtra, Mumbai as one market, Pune as another market, Bangalore as another market? There can be some subjectivity on that. And all I will say is that the case in hand that you're talking about, I think there is sufficient rationale for reading the way the commission has read it. But at the same time, unfortunately, even the Supreme Court, whatever it decides, it has some grayness to it. So I think with that, one could academically say that the market should have been interpreted a lot more broadly and should have seen the access that a player had, especially in an airport sector, which is monopolistic by its very nature, because you don't have many airports. Having said that, as I said, I think Commission has rightfully explored the Green Channel, has tried to look into the market definition, But this is one area I'm sure which will evolve over a period of time. And I think this is a great case, I would say, which allows all of us to only make it better. I don't think we have really committed any blunder by doing what we have done. There is a rationale, and it's a great case. As I said, the future can only become better than the past. So on that, I would pause.
Okay, all right. Mr. Sharma, you wanted to make a quick point on the question, on the key takeaway from this particular case. Also, sort of, Himanshu has said that maybe we have not committed a blunder. From a consumer point of view, would you agree?
Certainly. I would not like to respond to what Himanshu said. He's very right. Green Channel has been a very positive development as far as Green Channel, this COVID is concerned. And CCI has done wonderful, there's no doubt about it, except for the fact, one comment which I like to make, the Green Channel is really green, because the point, I'll come to the Irani case later, because there's still the fees to 20 lakhs to be paid. So that is an issue which I maybe take later on. But what the issue about Adani's case is that the market, the way it has been defined, leaves certain questions unanswered. It has been very narrowly defined, you rightly said. And also the fact is that in another case, as I was just saying, the same commission has defined the market in a product manner, that all airports in India. But in this case, they have only considered Mumbai as the relevant geographic market. Admittedly, there are no overlaps between Adani and this airport business. Absolutely not. But the point is, if you want to define the market the way the acquirer wants you to define, then certainly it leaves certain questions to be answered. I mean, I cannot say more than what I can just say, a few words that this is a one-off case. I hope it's one-off case. Ideally, it should have been a Form 2 case. It should not have been a Green Channel at all, because the same group is also winning bids in other airports also, which certainly a regulator like market regulator should have taken note of. I just can say that. So it is a one-off case, I hope. And but there's nothing wrong in it, because as far as Mumbai is concerned, yes, there was no overlap, and certainly I hope the efficiencies do come in. And I mean, it's a mixed signal going to the industry.
All right. Okay.
I mean, I'll just stop here.
Sure, Mr. Sharma, thank you for candidly and very nicely putting across your view. The second inconsistency that I personally found was that a player that's being investigated for abuse of dominance in a relevant market, a minority acquisition by the same entity in the same market didn't merit a Form 2 filing. And for the purposes of clarity for the panel and the audiences, I will put the name to it. And of course, my panelists can just comment on the principle of the matter. In a prima facie order, the regulator found Google Play that it accounts for 90% of app downloads on Android smartphones. And Google, in its investment of 7% in Jio, which is also a player in the mobile applications market, the filing didn't sort of, to my mind, do justice to it, because the vertical overlaps of this nature, in my assessment, did deserve a deeper investigation. Dr. Gimawat, can I come to you with this principle on what you made of reading these two developments together?
Thanks, Paiswini, and thanks CII for inviting me to share my views on this. Paiswini, I would first go to your Adani issue as well, and when I would be commenting on this, that would answer this Google issue as well. I think two things. The legacy of merger control, the last 10 years experience has been very, very praiseworthy, undoubtedly. So two things which I want to mention is that one is the legal issue. Legal issue in terms of when a competition commission analyzes or assesses any proposal, it assesses on the 14 factors which are provided under Section 20. But then out of those 14 factors, the relevant market is one such factor. But largely, the tradition has been that the relevant market has always been at the forefront in terms of assessment of any proposal. And that's the reason why whenever we analyze any situation, we are only talking about the relevant market and not the other factors. Other factors are multiple other factors as well, but then we normally limit ourselves in terms of the geographical market or the product market. So this is one legal issue which I want to highlight, that any proposal gets evaluated on those multiple parameters. And that's the reason why we think that what happened in the Adani case, whether that was abnormal or normal, But then there are other reasons as well while approving this, and the same principle applies as far as Google and Jio is concerned. But then there is another interesting factor which I think in my experience I think that's the right factor. Adani perhaps might have taken a chance of filing green channel route, and for the simple reason that Adani perhaps realized that the way in which the Competition Commission is progressing on the merger control regime, which is so industry friendly, so ease of doing a business kind of scenario, in a situation like this, it will the proposal will get through. Why I am saying so? In the initial phase of Competition Commission's merger control regime, even in those cases where we used to think that the Form 1 would be sufficient or would be the right filing, still we didn't take chance in the initial phase because we thought that there is no sense in terms of wasting time in Form 1, because if the Competition Commission raises one or the other issues, ultimately we will end up filing more documentation. So it's always better to file Form 2. But the history suggests, the experience suggests that no, Competition Commission is very industry friendly. They are dynamic, and the kind of words which you have used in terms of agility and promptness, I think those are the right words to characterize Competition Commission. So I think these two factors were relevant in terms of this inconsistency which we are talking about. But I think the way in which the things are progressing, I don't think that these are abnormal kind of situation. These are very normal kind of situation. Yes, in a general thought standpoint, we can always distinguish that had it been a different case, or had it been any other institution of the government, they would not have perhaps approved this proposal.
I'll come to Nilesh also with both the Adani and the Google inconsistencies that appear to me at least, and seek his views on it. Nilesh, did you find it surprising what unfolded or unraveled in both these situations?
Yeah, so I think Adani, I already made my comments with respect to this Google matter. I just want to make a very general comment with respect to this digital market space, that we should all appreciate that this digital market industry is still relatively an emerging industry and a new age market. And CCI may have taken that into account while they sort of looked at this case, and therefore could have taken a little bit.
That would require, or that would prompt any regulator to be even more careful, since it is a new market.
Yeah, but that's what I mean. I would hasten to add that CCI certainly is continuously strengthening its enforcement ability to review the transactions in these digital market space to test their anti-competitiveness under the present merger control regime. But that's what I feel could be one of the reasons in this particular matter.
All right, Mr. Sharma, you wanted to make a quick point?
Yeah, I just wanted to say that on the Adani thing, I omitted to mention something very important, that as per Schedule 3, because I said that in the beginning when I was not audible, the Schedule 3, which is attached to the Green Channel, actually mandates the Commission to consider all plausible market definitions, which is what was missing in this particular case, unfortunately. That is one point. The second thing about this Google case, which of course nobody wanted to name, but it's very obvious. Listen, Payaswini, the point is that there are difference between an antitrust investigation and an investigation or an inquiry under the XNT, which is for the merger. Mergers control all over the world are lighthearted, right? As compared to the antitrust. So you're right that in a 26-1 order under prima facie order, CCI said that Google has got a 90% market share in the Android operating software and even in the Play Store also. That is when they are investigating a complaint, right? But when they're investigating a merger where this company is taking a stake in a company in India, where it is not present in that market yet, I think the CCI has rightly done, has to have a different standard. Yardstick has to be a little dilute than what it would do in the case of an antitrust investigation. So that is the quick point I wanted to make. I'm not trying to say that your point is not well taken. You're very right in saying it apparently appears that there is a dichotomy, but that according to me, there's no dichotomy. Merger regulations all over the world are light-hearted. Thank you.
Sure. I take your point, Mr. Sharma, and the intent is not to find faults in any way in what the CCI is doing. The idea really is to read the mind of the regulator and its approach for the larger benefit of the industry. My personal sort of observation was that in all of this legalese and the technicalities, the market reality remains the same, and a regulator like CCI cannot be, boxed in so much that that market reality, we lose sight of that market reality. Anyway, I'll come to the second umbrella or my second eye, as I'm calling it, of the interesting developments this year. I'll start with a very interesting Chris Capital and Intas Pharmaceuticals deal. For those of you who don't know what this deal was about, I will give you, a quick snapshot of it in brief. Chris Capital acquired an additional 3% stake in Intas Pharmaceuticals, taking its shareholding to 6%. While examining the deal, the regulator looked at Chris Capital's exposure to the pharma sector, which came to more than 30%. So it had to give certain voluntary commitments, like remove a director from the board of one of its portfolio companies and restrict use of information. Himanshu, you would have looked at this development very closely. What takeaways does this precedent have for portfolio investors like yourself?
Right. I think, this is a very, very relevant question and a very nuanced one. Let me put it this way. And whatever we are discussing is only to make things better. Just to start with, I think this is not, whatever has happened, as I said, has not been catastrophic by any stretch. So with that, I would say a couple of things. I think number one, the fact it was we looked at the interconnected party test, the gun jumping test, and what's really driving the market share when you said 30% and so on and so forth. I would say two things to that. Number one, if you look at the remedial sort of outcome here, one, let's not have a board seat on one of the portfolio companies. And two, let's not share information amongst those portfolio companies. Now, I want to just take a very long pause here to really reflect on the actual outcome here, which is actually already protected under law itself, to be very clear. That to start with, if you say don't have a board seat, and this is a segue to our control conversation, which we'll come to in a moment, having a board seat out of 5, 7, 10 members can never lead to undesirable results when you talk about influence or control or whatever. So the right to an investor is coming from the Companies Act itself, as long as there is proportionate representation on the board. Whether I have invested 3%, I appreciate there are thresholds in the Act itself, 10%, 25%. But if I am sub 10, and it is a proportionate representation, it's a right provided under law itself, number one. Number two, by having a board member out of 10 or 5 is not going to increase or decrease the influence that we are trying to sort of eliminate here or have the conversation on market share and overlap. So that's point number one. Point number two, on the information flow. Again, as a director, it is well, and there is enough jurisprudence out there that as a director, I dare not share information which belongs to a portfolio company. Let's be very clear. The information that we're talking about doesn't belong to the investor, doesn't belong to the financial investor, doesn't belong to any shareholder, doesn't belong to the promoter. It only and only belongs to the portfolio company. So a director by law or the shareholder by law cannot use information of one company to the other or vice versa for any purposes whatsoever. So the short point being that while we talk about whether 3% is a good threshold, 6% is a good threshold, and what it can mean by a control standpoint, we'll talk about that separately. But if you just work backward, what we have done was already protected under law itself. And by not allowing a financial investor to have a board representation, because the financial investor, by very definition itself, is not running the company, doesn't have an executive director on the board. All it is ensuring that the investment is protected. So it's minority sort of shareholder protection mechanism in the manner of speaking. And by the way, today the markets enjoy the premium. Please note that point. the fact that a great financial investor, some of our competitors, I would not want to say that we are a great investor, but some of our competitors, if they have their members on the board, it raises corporate governance. It raises transparency. Market loves it. The customers love it. Vendors love it. So the point I'm making here, long story short, that what we have done in Chris Capital, I will not get into why it happened, because that's for the Honorable Commission. As I said, in their wisdom, they have taken the right call. The comment I'm making is actually that the outcome is perhaps needed to be, it was required to be seen in a different light, because what we have done was already protected and covered by law itself. So I will pause on that.
Himanshu, I take your point, but equally you can't blame the regulator for being uncomfortable with a portfolio investor who already is 30% plus in the market, and then say, hey, look, everything is cool because, you know, it's all investor protection rights. So I'm not sure I fully agree with you that, you know, the regulator shouldn't do anything in these situations. What could be an alternate? Please make that point. But yes. I'm not sure that if it didn't require any action or response from the regulator at all, I'm not very comfortable with that outcome either. I'll come to you, Nilesh. What do you make of?
Personally, let me just make one point. I'm fully with you. Don't look at 30% in isolation and talk about, I'm sure regulator would have seen it. All I'm saying is look at what is happening in the 70% of the market. Is it well dispersed? Is it all scattered? Is it concentrated? And what is my role if I have 3 other investments or 5 other investments, all minority investments? Please, that's very important. If I have one investment with 25% and plus and 3 minority investments, one could say it. But if I have 30% spread across all minority investments because I like that sector, that cannot be used against me because I do not have influence on either of those companies. Put together itself, I cannot really lead to any disruption, which the regulator may be concerned with. But as I said, you know, I'm just purely looking at from what I have seen it. The output is purely proportionate to the input. So I'm just reacting to what I'm hearing from you on the panel. So over to you.
Dr. Kimawat, I'll come to you. Give us an industry view on this, that a portfolio investor who is, let's say, also invested in some of your competitors, do you find comfort in the fact in what the CCI has done in this case, given that this particular investor had, you know, the market share of 30%? Does this outcome give you some level of comfort?
Well, you know, personally, it depends from industry to industry. There are industries where we have common directors. There are industries, for example, in cement industries and some of the companies and listed companies, we have common directorships. So and that to the independent directors and all that. So in a situation like this, I echo the same sentiments as Himanshu has expressed. These kinds of aberrations are not good for the industry, and ultimately we need to see that finally what is the consequence and outcome of all this. Now, you may remove a person from a directorship, but it doesn't necessarily mean that he will not get involved. Now, these kind of measures might be perhaps relevant in those jurisdictions who are not having any awareness about the competition law and the merger control and the corporate governance and all that kind of thing. There, you need to take these measures because you create public opinion through these kinds of initiatives or these kind of measures. But then in a mature jurisdiction today in which we are in, as regards the merger control is concerned, I'm sure everybody would agree with me. So in a jurisdiction like this, I don't think that these measures would be required or these kinds of orders should be passed for the simple reason that obviously there is ultimately no consequence and outcome comes out of these kind of aberrations.
Okay, all right. I take your point as well on this. And let me go to Nilesh with the second interesting development that I found this year was the gun jumping order against Canada Pension Plan Investment Board, which acquired a 16% stake in Renew Power. Post this, Renew Power acquired Austro Energy, which the regulator interestingly found out via a press release by parties. A very alert case officer, I might add. The CCI noted that Austro transaction was in fact funded by Canada Pension Plan Board investment and imposed a 50 lakh penalty, and perhaps rightly so. Nilesh, this is a significant increase in penalty amount from the 5 to 10 lakh earlier. Will it prompt industry to take gun jumping seriously? The regulator has been making, and we have discussed this point to death on interconnected transactions. If the industry still doesn't get it, the regulator clearly can't be blamed for increasing the penalty amount in the fashion it has.
Yeah, I agree, Payaswini. I think perhaps because of this outcome and the fact that the industry needs to sort of take this, either of it, whether a procedural gun jumping or a substantive gun jumping seriously. I think perhaps this kind of increased penalty will definitely, be a message to the industry to sort of look at it more carefully when they sort of go ahead with, effecting any of these transactions. So I think that would certainly have a deterrent effect, is what my sense is.
Okay, Himanshu, you don't agree with this outcome?
You are not only a moderator today, you're also a judge, because when you ask a question, you give your judgment as well. So it's very difficult to argue against that.
I'm just trying to add some flavor and character to the We're in a remote location, we have to have some fun, right?
Absolutely. Whether remote or in person, always good to have that. Let me say the following. We deal with this topic every now and then, and I think there is a bit of a human angle to it, if I may put it that way. Let's just talk about that for a moment. We are looking at, especially the large deals, you're looking at a big asset, and the growth is coming from the asset. And I'm just going to talk about a bit of business here for 60 seconds. You're also valuing some of the assets that are going to fold up in the future. In other words, you're looking at a sector, you like the company, you have 5 other companies that you want to acquire, or 1 other company, whatever it is. But at the time when you're making a decision to invest, you sometimes do not have the final commitment, because everything that you disclose to the CCI goes to the world at large, and rightly so. So when we say, because today you close a deal, and the 5th day after closing the deal, you look at another asset because you did not get the commitment during you wanted to do the deal, every lawyer in this country would say that is gun jumping. You had always decided to do the second deal, but you did not disclose. Therefore, you're in trouble. Now, what this means is that even if I don't have a deal on the table day 1, when I'm trying to do the main larger deal, and some of the deals have to happen later, I do not have the privilege to go out there and disclose something in a premature way. If you understand, because everybody talks about saying you do the first deal, and only if the first deal happens, I will do the second deal. But what you are telling me now is that I've got to make sure whether the first deal happens or not, I have to announce the second deal at the same time. So therefore, the short point being, and I don't think we can solve it on this panel, this happens all the time, if the parties are being deliberate, are being intentional about not disclosing something, yes, by all means, why 50 lakhs? There should be a lesson out of it. But if commercially parties are not there genuinely, and they think that it can happen 10 days later, 30 days later, 45 days later, let the business decide that, as long as you have commitment from the acquirer that they will make the necessary filings and they've got a good, clean track record. Private equity has filed more filings this year than any other industry to start with. Everybody loves CCI. So let's not find an exception, or let's not have a tail which can wag the dog, is the short point I'm making. Let us believe in the industry. Industry will do the right thing. We are here to do business. We're not here to scuttle CCI filings. That's the short point I want to make.
So, Mr. Sharma, you want to quickly add to what Himanshu has said?
I think Himanshu is into it.
Mr. Sharma, we are having trouble with your audio again, I suppose.
Can you hear me now? Can you hear me?
Yes, this is better. Thank you.
So I was saying Himanshu is deep into this, and I'm sure that he would certainly know better, and that's what he said, that intention alone should be seen. But the law as it is drafted, it is not only the intention, it is the effect which is seen. if you are missing it, you're missing it. As simple as that. What I'm saying is this particular issue which you pointed out of this case has sent a message to the portfolio investors that they have to be careful. Substantial conjuncting is now on. The procedural conjuncting is no longer there. So when you have a duty, an obligation to self-assess, you should not that you're going to, you're going to be having this coordinated effect. For example, if not a single firm dominance. So even coordinated effect also could be seen by the commission. So that is the message I think this order sends to the portfolio investors particularly. That's my take.
Sure. The final point that I want to cover under the interesting umbrella theme is the recent notification by the regulator on doing away with disclosures on non-compete in Form 1. Of course, the regulator did take, stakeholder comments earlier in the year, and now that notification has finally come in. Nilesh, are you sort of glad that, this has come in? Or do you see this as, earlier if, CCI gave the blessing to non-compete, the parties would more be at peace. But now, do you think, as parties, you would have to make double the effort to ensure that you're not violating the Competition Act, because now the onus of, making sure that the non-compete, doesn't violate or is not anti-competitive, is on the deal parties?
Yeah, so I think in the present, before this notification, I think CCI did intervene and looked at the non-compete obligations necessarily to see if they are reasonable. So they looked at it from a perspective of duration over which the restraint could be enforceable, or the business activities or geographical areas and persons. So basically, there have been instances in the past where CCI has intervened and approved the transaction only after the parties have agreed to modify the scope of non-compete clauses. Now, this particular disclosure requirement having gone, I'm not sure whether it will be very favorable to the industry, and perhaps there could be more stricter or wider non-compete clauses which could be levied, which could then ultimately, result into an appreciable adverse effect on the competition. So perhaps that could be an element here, is what I feel.
All right. Okay. The third theme that I'd like to come to now is what I'm calling irritants. Issues essentially that we've all discussed ad nauseum in the past, but they continue to be painful. Himanshu, I'd like you to go first with your gripe or continuing gripe with control, decisive influence, and material influence.
As I said, you're putting me on spot by saying irritant, and then you say, speaker, you talk on this, as if I just want to make sure that I have not made it like a pain point. This is Paiswini who's made it to the commission at large and to Mr. Bishnoi. I'll see the.
I'm just having some 9 p.m. prime time news fun here.
No, that's right. But on control, I would say the following. We can go on and be a critique on the definition of control. World loves it. Lawyers love it. It's a lawyer's delight because there is a lot of subjectivity in what is control. But if you think about it, I must applaud here first that the CCI is the only regulator which is actively trying to find a solution on control. And we cannot penalize, or we cannot, of course, we dare not even use the word of penalizing the regulator, but we cannot even comment in a negative way on their sheer willingness to solve this problem. As you know, SEBI has not been able to do it. While SEBI has done a phenomenal job, they continue to do it. The industry really appreciates it. We still don't have a final list of what is control. By the way, RBI has a different meaning. The Companies Act has a different meaning altogether. Worldwide, European Commission has also not defined control, to be very clear. So it's a bit of an art that we're dealing with than science. So we got to acknowledge that. That's one. Two, I would say that if you look at the law review, the proposal on the control, I think it's very heartening to see, because what they are saying is that it's going to get solved by subordinated legislation, and what they have said, that provide some guidance in terms of what are those rights which will be problematic and what are the rights which will be not problematic. Again, a great attempt, and I've been saying this, that I want to work with the commission on behalf of the industry to come up with that list. It won't be exhaustive, it won't be definite, I appreciate that, but it will be indicative so that people like Payaswini can first absorb it well, educate everybody well before going to the lawyers, right? We would love that. So that's a great move again. The only thing I want to emphasize here, and I've been saying it right from day one, and I said it earlier as well, please do not link control to a mere board seat. Please appreciate that. In a Google case, Facebook case, all the strategic guys, they are doing whatever they are doing and having a board seat. That is one broad brush that we are looking at. But a financial investor having a board seat, as I keep saying, if Blackstone has a board seat in Infosys, which has 13 directors, or in Tata Sons, they are all great companies. Just the fact that you have a board seat, by definition, by any stretch of imagination, at least at our end, we don't think that we have any influence. We cannot. Companies Act recognizes it. SEBI recognizes it today. RBI recognizes it, and so does the rest of the world. So my only sort of suggestion would be, I think we're moving in the right direction. We're very thankful. We are happy to work with the commission. This material influence versus decisive influence, I leave it to the lawyers. Those are words. Let's not spend time on it. Let's constructively come up with some indicative list, which is what happens in Singapore, which happens everywhere, and then take it from there with a clear footnote to that conversation, a mere board seat. Please, let's just actively debate on that at another time, that should not just personally lead to control, because that's the only thing that a financial investor really looks for and allows the industry to further develop by bringing in the best-in-class talent at the board, which increases corporate governance and standards. So that's what I would say on the topic of control, personally.
Sure. Thanks, Manchu. And I take your point on the specifically for financial investors, how CCI might want to at least illustratively indicate what would or what would not amount to control. And I guess CCI, I mean, has always been open to consultations, and I believe it wouldn't be, or I don't see why it should be different this time around. Dr. Gimawat, I'll come to you. On the second irritant, that is public market purchases. The proposal was floated last year, but we still haven't seen a final sort of notification on it as yet. It's part of the competition amendment bill, which we hear might get here in the winter session. But if it doesn't, in the interim, is the present painful, or have now businesses made their peace with it?
Well, the way in which I look at it is that, of course, this is desirable, this is needed. There is no second thought about it, because transactions cannot wait. Transactions will have to be done at a particular point of time. Otherwise, it's all impacting the businesses. And let me give example here why at times on a behavioral modifications or structural modifications, parties agree to what CCI is suggesting, or parties are voluntarily suggesting this, because only because they want to conclude the deal at a particular point of time, at a given point of time. And from that construct, if I apply the same principle, then it appears to me that yes, this is highly desirable in terms of conclusion of the transaction at a particular point of time. But then ultimately, what is the benefit arising out of this? The benefit is only that tomorrow you would not be making allegations of gun jumping. Now, if you have raised that issue of the gun jumping as well. Now, in a gun jumping kind of cases also, if you notice that so far the experience has been what? The experience has been out of nearly 750 odd kind of merger notifications, perhaps around 39, 40 merger notifications, there the CCI has found that there is a gun jumping. Now, even in only one case, there was that the party was penalized. Now, if we have this kind of data of last 10 years, I believe that these kinds of amendments and changes in laws are very much desirable, because in a situation like this, transaction should happen, the business should continue, and so from that perspective, it appears to me that this should ultimately go through, and this is desirable as far as industry is concerned.
Okay, so Himanshu, do the suggestions of the CLRC on market purchases and what we have in the competition amendment bill? Do those work?
Everything works in India, especially coming from CCI. Let me start by saying that. You're doing your best, I must say. So I'll say this. I think this requires a detailed discussion, honestly, because we have taken too long to actually deal with this topic. It should have been on the table today. If I give you a data, 70% of the financial quality capital that we talk about is actually through FII, 60 to 70%. And if you have to do, by definition, they have to do on-market deals. And the moment you talk about having a board seat, minority protection rights, by definition, nobody has 30 days to solve that problem. We all know the problem statement, which is a good thing. But we got to act fast on it. I think last year, just the same time, we were having the same conversation. We have taken too long, and these deals happen very fast. That's point number one. Point number two, I think the proposal is a good proposal, but it has to be better than that. Because I continue to believe that the solution has to be better than the problem. Otherwise, it doesn't really solve anything. And what I mean by that is that what the proposal seems to suggest is that you go out of pocket, put in billions of dollars to buy the shares and have no visibility, no voting rights, no observer position, no minority protection rights, and you hope and pray that everything goes well. I think that's one area. I've seen some of the other jurisdictions where they have allowed basic rights to be, you don't want to have board seat, allow the observer at least, minority protection rights, that nobody should be using that money for an improper mean, cannot just go in a direction which nobody had anticipated, and so forth, merger, acquisition, all of that. So the point being, it's a very slippery slope to start with, to say that you go out of pocket for billions of dollars and you have no protection, whether for those 25 days or 30 days. That's a risky proposition for any financial investor.
Okay, all right. I'll come to my final theme now, which is ideas, which I'm sure all of you will love because it doesn't name any cases. It doesn't put you on a spot. So I'm guessing everybody would love this theme. Dr. Kimawat, I'll come to you first. When we were chatting offline, you proposed certain ideas with respect to moratorium under merger control and market testing of remedies, especially in light of the COVID-19 pandemic. Over to you on these two ideas and what you'd like the regulator to do about them.
Yes. So, Paiswani, let me give my perspective, the experience so far with the Competition Commission. Number one, that no combination has ever been prohibited to date. There is no prohibition so far. In over 95% of the cases, there is no competition, no competition concerns. Now, if you take the data, there are only modifications out of those 750 odd merger notifications, only 35 or so, 35 or 40 cases, certain modifications have been suggested. So in this backdrop, we need to see how the law is emerging. There is a deemed approval concept. So within now from 210 days, you have reduced it to 150 days. There is a de minimis exception. There are target-based exemptions. Green channel is already there. There are sector-specific exemptions. So many changes are happening. Now, take example of IBC. In the case of IBC, the moment these cases, went for CCI's approval, initial phase, even I got approvals in Form 2 within 18 days. Now, in a situation like this, I think personally that, and particularly because of the COVID kind of situation as well, I would suggest that there should be a moratorium should be announced for next 3 years or so. This would do a multiple kind of, the business building or the environment building or sentiments building. That one is that this institution was ahead of its time in terms of the ease of doing business and providing support to the industry, number one. Because why I am saying so? Because the background suggests that in most of those cases, CCI has always been concerned about the economic development and economic growth of the nation. So that gets reflected as far as its orders are concerned. Now, if this being the situation, why not to announce moratorium? Because this will give a completely change the kind of feeling as far as business sentiments are concerned, or the foreign investments are concerned, or even the domestic investments are concerned. So this is one factor which I wanted to say. The second aspect is, and I have personally experienced that, even in those cases where behavioral modifications are suggested or voluntarily suggested, or the structural modifications are suggested, those modifications are no longer relevant in a country like India. We are progressing in that kind of speed. We have today the demand supply, huge gap on demand supply. So in a situation like this, where we need a huge economic development and a huge economic growth, now I think those kind of even modifications should not be suggested, because they lose their relevance. Take example, for example, in Holcim Lafarge case. If suppose you are saying that a more than 5% market share participant should not be participating as far as that bid is concerned, I think that doesn't stand today. Even in IBC cases where the participants are having more than 25% or 30% market share, they are also acquiring assets in those markets. Now, so in a situation like this, with the time the change is so happening in a frequent manner, it's so much dynamism. So those kind of orders where you put certain modifications, they don't become relevant even in the next 1 year's time or so, because these decisions are being taken at a particular point of time, and with that apprehension that this would be impacting as far as the market is concerned. But then when we consider the relevant market, we don't consider the ultimate beneficiary. All our assessment and analysis, parties as well as the Competition Commission, it's based on the relevant market, but then that ultimate beneficiary is not being considered. Let that ultimate beneficiary be considered, that whether, even if there is a huge market share, but then as far as the customers are concerned, if they are getting benefited because of the good quality product, why to put these kind of restrictions, whether that is PVR DT deal or Holcim Lafarge deal or multiple of other nature. So this is what my suggestion would be. Yeah. Thanks.
Thank you, Mr. Gimawas, for a candid sort of suggestions. I'm not sure if the regulator can be asked to do away with the modifications altogether, because at the time that the regulator is assessing a deal, it does need to take into consideration the market forces. To give a free hand, I don't know how realistic that ask is. But of course, there can be ways around it where parties are finding it difficult to continue with those behavioral commitments. Probably a window or a provision can be made for them to go to the CCI to ask for a dispensation of some sort. That, of course, I leave it to Mr. Bishnoi and the rest of the members to respond to. I'll go to Mr. Sharma very quickly. Mr. Sharma, under the ideas theme, you had certain thoughts on standstill obligations, getting suspended, or situations where the regulator can consider derogation of standstill obligations. Mr. Sharma, can you hear us? Okay.
Am I audible?
Yeah, you're audible now, sir.
Okay, because I'm logging from the mobile, so some technical problem has come in my laptop.
Please go ahead, sir. No problem. We're all used to it.
Yeah, so there are two things which I want to mention. The first is regarding this IBC, which I think my previous speaker also said. So in the IBC cases, so the CLRC, the report had recommended that IBC be taken through the green channel, but the commission has not done it. Green channel doesn't include cases under the insolvency, right? And I think that is right, because public interest doesn't demand that every green channel, every insolvency case, because the acquirers are going to be there are going to be competition issues. So that is the one which perhaps there is no question on that. But as far as the derogation of standstill obligations is concerned, the CLRC recommendations are on two aspects. One is on the public hostile takeovers and the public, hostile takeovers and the public bids, etc. For that, the CLRC is recommended, and I think that is captured in the amendment bill also. But what has not been captured is situation like where there's a cash crunch. There are situations in COVID, and we are living in a very different situation. There are cases where the companies are going, they may not have gone to the insolvency level yet, but they may have a cash crunch. They may not have the cash to run the company. They may not have defaulted, fine. But there may be a prospective acquirer waiting in wing who may like to give a loan for the running the day-to-day business of the company. But can he do it? He cannot, because if that is a combination, you have to go to the CCI. So in such situation, should the commission not consider derogating the standstill obligation for the time being? And this is, of course, for the law to take. It's not the commission, it's not in the commission's hand. It has to go to the parliament, because section 6(2)(a) will have to be amended to incorporate such situations. Second example I give is the recent example of, you all might have seen the Reliance, infusion of fund into the Big Bazaar, Biani's Big Bazaar. So what has happened is that the Big Bazaar has been given funds by Reliance, and there is, I don't know, this is still going on. So I don't know whether the CCI will come out with a notice, because that is actually violation of the law. Technically speaking, would CCI come out with a 43A notice against Reliance Industries? Because I remember we have some experiences in this, because there was a case, I will not name that case. A company was ready to pay advance of 15 lakhs, and that was refundable. There was a clause specifically mentioned in that agreement that it will be refunded in case CCI doesn't give approval. But that company was also penalized. So, and there are, of course, Unitech cases also there. Hindustan, there are various cases. So the point is that these kind of situations which are now warranted because of the COVID situation, the companies are not always in a good health. And in that situation, would the commission or would the government not consider derogating the standstill obligation in situations where a prospective acquirer wants to help a company which is going down, right? But it cannot, because you have to go to the CCI and it takes time. So by the time this is done, the company might go bankrupt. So there may be situations where derogation is seriously required. I think this is what I wanted to add. Yeah.
Sure.
So standstill required a lot of this discussion.
Yeah, I'll finally, before I go to Mr. Bishnoi for his wrap-up comments, I'd like to come to you very quickly. You had a 6-4 versus 6-2 conundrum. You want to lay out that for us very quickly?
Yeah, I think we've had a good afternoon. Why don't we just leave it there? But let me outline one of the unattended provisions in the Competition Act, which is 6(4), 6(5). We all know that 6(2), what 6(2) and 6(3) really deal with. Whenever there is combination, we come to the CCI and do a fraud. If I may request, whoever is not speaking to go on mute, would be very appreciated.
Yeah.
Thank you.
Yeah.
So I think 6(4), actually, if you read 6(4), it deals with investments done by financial institutions, FIIs, FVCIs, and so on and so forth. And we had a situation where we actually had to spend a lot of time on this topic, and we had a great learning from it. And we were very much engaged with CCI, and I thought that this was one of those cases where literally the partnership with the regulator came to the fore, and we collectively sort of went through the jurisprudence around it. So there are 2 points I would like to make. That FIIs, everything that the foreign investment or foreign investor does is not the same. There is FDI, there is FII, and there are other routes available. And 6(4), interestingly, deals with topics that if deals are done by FIIs, let's say there are structured deals. When I say structured deals, there is debt element to it. There is an on-market deal, and so forth. As long as those are done by FIIs and FVCIs, the regulation actually says you don't have to come to CCI in advance. You can very well do the deal and then notify. So it's a post-notification one. But unfortunately, there have been some filings in 6(2), 6(3), so there is a lot of sort of confusion around that. I think so that requires some more deliberation that how we can use the existing framework for the on-market deals, for the debt deals. So we don't have to change the law every time whenever we talk about a problem. The solution is in the Act itself, but it's a very dense topic, so we should find some other time to do it. The only thing I would say in a constructive way, I think there should be a filing fee for 6(4), 6(5), because the difference between 6(2), 6(3), and 6(5) is for 6(2), 6(3), you pay whatever filing fee, but in 6(4), so while the good apples in the market don't really are solving for the filing fee. We don't know whether there are bad apples who may just want to use 6465 in a mischievous way and not file the filing fee. So the point I'm making is that while we solve the substantive issue, I think procedurally we should have filing fee for 6465, which will basically level set the 6264 analysis, and people will be a lot forthcoming to really talk openly about structured deals, on-market deals done by FIIs, which could solve a huge problem for for investors such as Blackstone and some of our industry colleagues. You're on mute, Paiswini. Paiswini, you're on mute.
Okay, thank you, Himanshu. I should have actually sort of flagged off right in the beginning to all our viewers that they should be sitting with the Competition Act. So my sincere apologies for not making sure that that didn't happen. Thank you all of you. Thank you all the panelists for making in all your points and candidly answering my questions. Before we move to the Q&A session, I would like to invite Mr. Bishnoi to respond to the extent that he can presently to the comments that our panelists have made and give us his wrap-up comments.
Thank you very much, Payaswini. And firstly, I want to thank the panelists. They have really rallied around the regulator when the moderator has put the commission on the spot. So thank you very much, all of you. And I'm really very impressed by the level of the dialogue that we've had today. And the interventions by the panelists reflect both the depth of their understanding and also the deep thought that they have given to the subject. So thank you very much. I won't speak of specific cases which may have come up for discussion today. That may not be very appropriate. And I'll only briefly touch on some of the matters. These are in the nature of preliminary observations. Because the interventions have been very substantive and they will receive full consideration by the Commission. I assure you all of that. So there was the suggestion of moratorium on merger control. Now, I mean, it is of course true that the pandemic has dealt a very serious blow to the economy and businesses are struggling to remain afloat. That should, in my own personal view, however, not lead to a situation where big players have a free hand to acquire smaller players without any regard to the competition issues that may arise. Now, that being said, I must acknowledge that there is an extraordinary situation and there is a duty on regulators to ensure that, one, they don't impose any additional compliance burden. Number two, they carry out the duties with a light touch. The government has been very clear about this approach, and the Commission is also fully committed to it. Our assessment and clearance, I think there was a remark about the fact that we do it in fairly expedited manner. So while we have a self-imposed deadline of 30 days to clear combination proposals, at the moment we are taking about 18 days. So we do need to keep a balance between quality of assessment and also the time taken. So we will always be acutely conscious of that. On the Green Channel, there have been various remarks, and this, of course, the Green Channel is an outcome of the deliberations that took place in the CLRC. Our first Green Channel was approved on the 7th of October last year, and since then we've had 19 cases. So this roughly translates into 1 in every 5 cases coming under the Green Channel. With regard to IBC cases, they can use the Green Channel in case there is no overlap. And if there is regular filing, then the Commission is, of course, very conscious of the failing firm argument. And so I'm not very sure if there is a need to go beyond this. Mr. Sharma had made in his initial remarks the suggestion for doing away with, for having a reduced filing fees for Green Channel. We'll certainly give it thought, but I must mention that the Green Channel doesn't mean that there's no assessment by the Commission or that the level of assessment is in any way lesser. There's been some discussion on what constitutes control. This, of course, is not an easy subject at all. And it would be difficult for a regulator to have a straitjacket formula, as it really boils down to the substance of the transaction. And there are, of course, cases where even economic control has been held to be material control. Now, that being said, we have taken note of the suggestions and we have talked with them. And the Competition Amendment Bill, if approved in its present form, will provide some clarity on what is covered by Section 6(4). Then you have briefly touched on market testing of remedies. Till now, we have largely relied on consultation with stakeholders while devising remedies, and our experience does lead us to believe that there is merit in taking into account voluntary remedy proposals. On the non-compete clause, you have noted that this was introduced after consultation with stakeholders. And the reason why we did what we did was because we felt that prescribing a general set of standards for assessing non-compete clauses is not very practical given the dynamic business environment. And we also need to do the assessment in a rapid enough manner. So in conclusion, I just want to thank all the panelists. The feedback which we received today and which we hope to continue to receive is invaluable for us. And thank you very much to the CII for organizing this very important conference. And the moderator, as always, has done a wonderful job. So thank you. We lost Pius.
Yes, I'm back.
Thank you.
Okay, you concluded your remarks. Thank you. Thanks a lot, Mr. Bishnoi. I think I missed the last 5 seconds of your remarks. But I'm also, as a journalism student, I'm taught that let no opportunity go by to interact with regulators. And I see we also have Dr. Pandey here with us. So if, Dr. Pandey, you would also like to sort of add to what Mr. Bishnoi has left us with, and any remarks or any comments by you would be deeply appreciated. Dr. Pandey, I think you're on mute. Would you like to say a few words before we move to the Q&A session?
Paiswani, if you please permit, can you also request the honorable member to comment on the standstill obligation which I suggested?
Mr. Sharma, I think points that Mr. Bishnoi wanted to, I think, comment on, he has already. So I'm sure we'll get many future opportunities to sort of interact with the CCI. And thank you, everybody. We should move on to the Q&A session now. I should, on this Friday afternoon, Chitra tells me there are about 600 people watching us live. So thank you, all of you, for listening to us. And of course, we are open for questions. I will read out from some of the questions that we've got so far and take them to our panelists. The first question is, and I think we did touch upon this in a degree of detail, but you still require a response to it. Why not? The question essentially is that as per Schedule 3 of Combination Regulations, we understand that for adopting green channel route, all plausible alternative market definitions have to be looked at to rule out overlaps. Does the Adani decision effectively amend that to mean narrowest relevant market? Can I ask my panelists to I know Mr. Sharma already made that point. Would you like to reiterate for our audience once again?
Yeah. We have to see the law as it is. Rightly say that all plausible definitions have to be considered. But unfortunately, in this particular case, only the relevant geographic market has been seen and not the relevant product market. So that's a good question, and I completely
Okay, Mr. Sharma, we are losing you again. I think you're having some trouble with your internet connection, I believe, today.
Audible now?
No, sir.
Is it better?
Yeah, it keeps.
I think there's some problem with the internet only here at my side.
Yes,
Am I audible now?
Yeah, you are, sir.
Okay. So would you mind me to repeat or what?
Could you quickly, in a minute, summarize your final view?
I just wanted to thank for this question, because this is actually what I said, that the Schedule 3 of the regulations very clearly say that there is a need for considering all plausible market definitions. Unfortunately, the CCI in this particular case has only seen the relevant geographic market, that is around Maharashtra, which is, to my mind, is certainly needs to be looked at, and that's what I said. It should be only one-off case. That's why my thought is that it should be not be such cases should not be repeated. Thank you.
Sure. The second question is views of the panelists on having a provision for penalty computation. As of now, the person who's asked the question believes it's loosely worded and uncertain. Dr. Gemawat, would you like to respond to that?
Vice-Chair, I just missed that. Can you please repeat this, please?
The question is, what are the views of the panelists on having a provision for penalty computation? As of now, it is loosely worded and uncertain.
Well, if we are talking about penalty computation only for a merger control regime, or Section 3 and Section 4 cases as well. So I have a different view altogether as far as Section 3 and 4 cases are concerned, because
so since it's a merger control panel, I think we can stick to your views on 5 and 6.
I think, in a situation like this, I think, look, just an example. In gun jumping kind of cases, what the law authorizes you to penalize by 1% of the turnover and 1% of the assets. There is only one case in the history of the merger control, that to the case which you mentioned. Only amount is 50 lakhs. Now, so I would say that yes, there is a huge flexibility given as far as the law is concerned. But then I think CCI is cautious about this fact, and they are not imposing, unmindful kind of penalties as far as merger control is concerned. So all compliments to CCI, as far as these penalty issues are concerned.
Nilesh, I'll come to you with the final question that I have here. I'm not sure how or what the app response to this would be, but give it a shot. Out of 700 plus combination orders thus far, not a single transaction has been blocked by the CCI. Somebody's actually aggrieved with it. Is that the notifying parties have filed non-issue matters only?
Sorry, I think perhaps this was one of the thing which was considered by the CLRC, and maybe that's the reason this green channel option has been brought out. I think that has already been addressed by bringing out this green channel option.
Okay. So, I mean, you're essentially saying because there are no sort of grave concerns in most of the matters is why the regulator has facilitated a speedier window.
Correct. So that they don't have to spend time on all the matters, but concentrate on those matters which will have an appreciable adverse effect.
All right. I see these are the questions that have been passed on to us. Chitra, I leave it up to you to wrap up this session. Again, very quickly, thanking panelists, Mr. Bishnoi, for finding the time to answer all the specific, points that were raised in this discussion. Thank you, everyone.
Thank you, Vice-Chair. Thanks, everybody.
Thank you so much, Vice-Chair. This has been superb, and I think from the comments that I received from the participants, I think they elated with the discussions and all that we sort of spoken now. So I'm just going to conclude with a very, very special thank you to Mr. Bishnoi sir for all the time and for his comments very, very candidly and in a very crisp manner, sort of conveying what the CCI sort of has in mind. So thank you very much, sir. And a very special thank you to Dr. Pandey at CCI and all the officials at CCI who have been extremely cooperative and been very, very helpful for us at CII to sort of put together this conference. And a big thank you to all the panel members, and the Payaswini, superb and seamless as ever. Thank you everybody so much.
Thanks a lot. Bye.
Thank you, everybody. Thank you.
Thank you.
Take care, everybody.
Thank you very much. Thanks.